Hello and welcome to another segment of Good to Know Family Law. Today we're going to answer a very important question. And the question is, what happens when the person who's asking for spousal support has been convicted of a crime against the person who's supposed to be paying spousal support? I hope that you find this video informative and a little entertaining. Today we're going to talk about what happens to spousal support when a spouse is convicted of a crime where the other spouse is the victim. In doing this discussion, we're going to talk about marriage of Brewster and Clevenger. In this case, both parties were doctors. They were in a 21-year marriage. Husband is a orthopedic surgeon, wife is a gynecologist, and they separate in August of 2013. The husband filed a request for a temporary spousal support order pursuant to the guideline. Now, this is kind of unusual. It's not unheard of, but for the payer of support to file a motion for temporary support, it was obviously done by this husband for tactical reasons. In his declaration supporting his request to pay spousal support, he stated he has been depositing $10,000 a month into a joint account to cover the wife's expenses and had been paying the mortgage and property taxes on the family home where the wife lives rent-free. He also asserts he should not be ordered to pay any more support to wife because she has been charged with several criminal counts for harassing him. So first of all, the reason why he's filing this motion is because he wants retroactive credits to when he's paying for these things, and he's probably asking the court to look at this as a payment when he's doing things like depositing money into the joint account and he's paying for the mortgage and property taxes. He doesn't want to lose credit by supporting this wife, then later on having to pay longer because he didn't ask for it. With regard to the criminal matter, what's important here, at the time that he filed this motion, she had been charged but not convicted. There was no resolution to the criminal case. The husband was just notifying the court that she had been charged with several criminal counts for harassing him. In January of 2016, though, wife is convicted of several counts committed against the husband, including stalking, vandalism, and unauthorized entry in a non-commercial residential place. The parties are unable to settle their matter and end up going to trial. And the trial lasts from October 2016 through January 2017. During the trial, the husband acknowledged that the trial court had reserved jurisdiction on his temporary spousal support request, but reiterated his assertion that he should not have to pay spousal support pursuant to Family Code Section 4325. So 4325 states that when a spouse is asking for spousal support but has been convicted of a crime of violence or abuse on the other spouse, they're presumptively not entitled to receive spousal support. So this husband was saying, yeah, I know that I asked the court to reserve jurisdiction, but why don't you move to a more important issue and deny her any future spousal support? And this is significant because this was a very long-term marriage. The trial court took judicial notice of the minute orders and sentencing hearing in the wife's criminal case. The parties stipulated on the record that their Duck Club membership would be assigned to the husband at a value of $65,000. Wife testified also at the time of trial, and she admitted that she had been convicted of some criminal counts, but she didn't specify them. She didn't say what they were for or that the husband was a victim. However, in her written closing argument, she confessed to having put a non-poisonous python and several rats into the home where the husband was staying.
Rats and snakes?
The wife then attempted to rebut the presumption of 4325, the conviction part, by saying that it was the husband who was the aggressor. He intentionally dislocated her finger when she refused to let go of his shirt during a confrontation. He screamed at her, picked her up out of his chair, and threw her across the hallway after she confronted him at his office during business hours about an affair. She had gone to the husband's office on a Saturday, gained entry with a key she had previously purloined, and surprised him at his desk. It was the husband who was the aggressor, according to the wife of each of these incidents. She was never the aggressor. And as a result of the husband's aggressive behavior, she suffered several medical conditions relating to her shoulders, hands, and feet, as well as suffering cardiac problems requiring hospitalization after the last incident with him. She then testified she is unable to practice as a doctor, so as a result, she began to offer medical weight reduction treatment to supplement her practice. The trial court's ruling were not in favor of the wife. In fact, the trial court ruled that Family Code Section 4325 applied in this case because the wife had not rebutted the presumption and set spousal support at 0. So the court specifically said that 4325 means what it says. If you are convicted of a criminal matter where the husband is the victim or the wife is the victim, then there's a presumption that you're not going to get spousal support. Now, during this case, the wife had argued that there were no convictions of violent crimes against the husband, that they were more like harassment, as I indicated, stalking, things of that nature. But the trial court made its tentative decision and determined that 4325 applied. And by the way, the court also said that the Duck Membership Club was valued at $60,000 and awarded it to the husband. Wife didn't like this decision of the trial court, appealed, and unfortunately for her, the Court of Appeal affirmed the trial court, holding that it must deny the wife's request for judicial notice of documents not presented at trial. Trial court did not err in applying Family Code Section 4325 or concluding that the wife failed to rebut the presumption on these facts. The wife failed to introduce documented evidence that she was the victim of domestic violence, and the statute does not require the conviction to be for a violent act. So that's the really important part of this decision is this wife was under the impression that there had to be violence committed against the husband that she was convicted of. And the court said, no, those were abusive acts, and therefore 4325 applies. And the trial court did not err based on these facts in ordering spousal support. Finally, the trial court did not err in finding that the husband's payments into the joint account were in lieu of spousal support. In other words, the trial court did not lack jurisdiction to make temporary support order retroactive because he had filed his motion, and the wife was stopped from arguing the payments were not in lieu of spousal support when she took the opposite position at trial. Now, this was significant to the husband because at the time there was a tax consequence or a tax deduction for him and a tax consequence for the wife regarding spousal support. And finally, the trial court erred by valuing the Duck Club membership at $60,000 when the parties had in fact stipulated on the record that it was $65,000. That's not an important part of the decision, but I say it just out of jest that the wife got something. She at least got $5,000 out of this divorce. This appellate court decision is a great illustration as to what happens in family court when a spouse has committed domestic violence against the other spouse and there's a conviction. The family code means what it says, that if there's a conviction, then there's not going to be any spousal support. The main takeaway from this case, and this is a big one, and that is that the crime doesn't have to be violence against the other spouse. As we see in this decision, it could be a crime that is harassing in nature. This should be something that is watched by attorneys, and people who are going through these type of matters should be keeping an eye as to what goes on in the criminal court. Thank you very much for watching Good to Know Family Law, and we hope that you follow us on our social media sites. See you next time.